All right, and everyone else, I'd just like to thank you for tuning in to this webinar. Our monthly webinars are designed to bring you practical information in 20 to 30 minutes that you can implement immediately in your practice. Today, I have the pleasure of introducing Ginny Allen and Eric Sanchez. They're both with GrowPath, and I'll let them share anything else they might want to about themselves. But before I turn it over to them, I'd just like to let you all know one more time that we will have time at the end to take questions from attendees. So please put any questions you have in the chat box, and I'll relay those to our speakers at the very end, and you guys can go ahead and take it away.
Thanks, Rachel. We really appreciate the opportunity, and thanks to Susan as well. So just real quick, my name is Ginny Allen, and I am Vice President with GrowPath. I'm an attorney, but I've had a long non-traditional career in business development and marketing. And Eric, prior to being co-founding GrowPath, was a COO of one of the largest plaintiffs firms in the Southeast for almost 20 years. So he's a big operational background. Anything else you want to say, Eric, about yourself?
Yeah, no, I run product. That's the CPO there, Chief Product Officer. The idea with GrowPath was just looking in the marketplace and seeing that law firms, it was in many instances were maddeningly inefficient. And we thought we can do some really cool things with technology to make it a little bit better, and we'll share some of that with you today.
So let's get started. So can you see... There we go. So before we jump in, we want to define the scope of what we're going to be talking about, because we realize that intake can mean a lot of things to a lot of people. And so what we're going to be talking about, and I'll go ahead and advance to this slide, is that place between your marketing efforts and your new clients, the client intake process. So from a potential client's initial outreach to the first conversation to your firm signing them up, referring them, or turning them down. That's the world that we're going to live in today. And our goal for today is to talk about, to hit the highlights of kind of the pain points that we see in our work with law firms in terms of the client intake process, and how to kind of address potential ethical pitfalls before they would occur. And like I said, we're going to do it by breaking intake down into these 3 stages, and just, again, really quickly hitting the highlights where we see issues in our work. And in terms of like why this is important, basically we understand, and I know you guys do too, that it's a new ballgame out there for attorneys. So technology is changing the profession, and it's also changing customer and client expectations. And so many of the rules of professional conduct hold attorneys to the standard of reasonableness. And I think one of the questions that we always ask is, how is the standard of reasonableness going to change as technology advances and you can continue to do more things? And I think that's why it's more important than ever to address some of these issues and for lawyers to get ahead of some of these issues. And one area that we've already seen technology change the rules of professional conduct is in the area of competence, or the duty of competence, Rule 1.1. And so today, lawyers, you're using a variety of ways to attract, engage, and convert leads online, including outsourced vendors and different kinds of software. And so we think that this leads, and what we see, this leads to 2 potential ethical pitfalls. One, the duty of competence that we just mentioned, and then responsibilities of a lawyer when using non-lawyer assistance. So one thing that we recommend when we work with folks is to develop a due diligence checklist for vendor selection. Because the real issue here is confidentiality, where they're storing your data, what happens if there's a potential breach. And so you really want to be careful in terms of the vendors that you select, and just make sure that you have a process, a systematic process for checking them out moving forward. Do you have anything, Eric, on this?
No, I think that's right, Jenny. I think you certainly, attorney-client confidentiality is the #1 thing you want to look at, but even having a vendor is a first step, understanding that you can get better with technology, and there's a real need to be able to organize and index your potential leads and be able to monetize them down the road, but more importantly, to be able to effectively serve your potential clients, both with information as well as customer service.
So in terms of the first part of the intake process, your intake source, that's just a really important thing to keep in mind. Moving on to the intake conversation. So in this section, just to level set, what we're really talking about is the situation where lawyers are using staff members to conduct that initial intake conversation. Because messaging is a really important part of intake, and so you want your staff member to collect the information and to make the client feel like, the potential client feel like your firm can really represent them and that you want them, but you don't want them to overstep. So again, we want to look at Rule 7.1, no false or misleading statements, and Rule 5.3, your responsibilities as an attorney who is supervising non-lawyer assistants. So that requires, making sure that those staff members have appropriate instruction and supervision. One best practice that we see is to use your technology to train. So these days, there's lots of opportunities for to incorporate training directly into whatever software program that you're using. This is a screenshot actually of GrowPath's intake software, and this shows one of our one of our training pop-up bubbles that says to follow up in writing. So when a staff member is going to change the intake status to turn down, they are automatically prompted to follow up in writing. As somebody who's created training manuals for lawyers and law firm staff that only get stuck in drawers, we found, the best practice is to put it directly in the application. Eric, do you have anything to add?
No, I think that's exactly right. You want to make sure that you assume nothing. When you're empowering your staff to interact with potential clients, you just want to be very confident that they're communicating precisely what it is that you want, the manner that you want, in the best possible way.
Yeah, and there's no better way to do that than to put it right in front of to put the information right in front of them whenever they need it. So the next potential pitfall in this conversation point in the intake process revolves around checking conflicts. And one of the things that we recommend is to, you want to make it easy as possible. And when I say show your work, you want to document that it's been done. And this is the point in the program where I am going to transfer between PowerPoint and Vimeo, because I still don't know how to embed in PowerPoint. So this is an example, and I'll let Eric take it, but this is an example of how you can make conflict checks really easy for the staff members conducting them. Eric, do you want to talk a little bit about conflict checks?
Sure. So what you're seeing right now is we're entering in the potential client information. We're getting the minimum amount of information necessary to get a conflict. You see we've got the information here. And we click on this little magnifying glass, and we immediately take you into the database, and it identifies similarly situated potential clients. To the left, you have a number of filters which would also allow you to customize this even further. So some lawyers may want to be really thorough. Others might be satisfied with the first name and last name. But we give you a variety of different ways to do this, which gives you, it actually goes well beyond reasonableness and takes you to what's really the state of the art in conflict checking.
And I think another important point and something to keep in mind is a lot of times these days your software can actually timestamp when that was checked. So if you have access to the audit logs that your software provides, you can actually have a record of who conducted the conflict check and when. So let's see. So for our last 2 points, we want to talk about intake outcome. And so the intake process, it's kind of your last chance, your point of no return to decide whether or not this is a case that you want to take. Because even if a potential client passes the conflict check and it sounds like they have a good case, there may be reasons that you don't want to take the case. And as lawyers, as you know, it's all about risk management. And so one of the things that we recommend as a best practice is to develop a risk management formula. And I'll go to our next video where we can talk about this a little bit.
So one of the things, while Jenny's getting the video up, we have several patents issued in our application. One of them is a tool that allows us to create customized algorithms, and one of the algorithms used is a case selection algorithm, one of the things that we hear commonly is it's not just about case selection, but it's also about risk mitigation. So for example, if you were in a jurisdiction and you were handling a case or had a potential lead from Massachusetts or Rhode Island, they may or may not have differing statutes. You would be able to actually create drop downs and select the different state. That could return a score that was either favorable or negative depending on the input. Here you'll see you have an attorney. You'll see the score shows a negative 100 there. There are other inputs in this will automatically start to add up the score. And this is really about taking that professional judgment that you have and kind of getting it to the staff level so that they have the ability to see what you think about the information that's being presented. This is not intended to replace it, but it's intended to be an aid for the non-attorney staff people. It's also helpful to take those leads and reduce them to objective metrics so you can see the overall quality as you look at it month over month.
And so what you're seeing in this video is a lot of times attorneys in law firms don't want to take a case if a client has already been represented by another attorney. So you saw the score go down to a negative 100. However, as the staff member is collecting the intake information and the extent of the injuries and the treatment that's required is going up, the score continues to go up. So if, for example, in this example, this potential client had to have surgery, this law firm decided that that was actually worth 200 points. So even though this might be a case that you would normally avoid because of the prior attorney relationship, you can weigh that against the nature and severity of the injury and then make a better informed decision. And the fact is that as the attorney, you don't even have to be involved in the decision until a little bit further down the road because your staff or someone else can complete this for you. So let's go back to our presentation. And then the final potential pitfall that we see, and I think it's really true in any relationship, is expectations. So is there or isn't there an attorney-client relationship? So whether or not you want to sign this client, or whether you want to reject the potential client, it's very, very important to be really clear about what the relationship is and when the attorney-client relationship is going to start, if at all. So is this video going to work?
So one of the things you can do this, if you're getting a lead on the internet, for example, you can have a checkbox where the client is making an affirmative statement. They understand that they're going to interact with your firm and it does not constitute an attorney-client relationship, that you're essentially going to get information and triage that lead. Once you've made the decision that it's not a matter that you want to represent, the best practice is to get it in writing, not just a phone call, but actually say, hey, this is not something that we're going to be able to help you with. I've seen some law firms have as many as literally 20 different letters for the same type of matter because they want to give them a little bit more of a custom or a boutique type feel to their decline letter, other than here's the bar referral number and have a nice day. They want to advise them specifically that there might be deadlines and they're not going to go ahead and they're not going to be able to monitor those deadlines. Here's an example of the types of mail merge functions that we have. That was an example of retainer. You can really customize the application to do whatever it is that you want. But even if you don't have a software that you're using, it's a best practice to have a letter that's templatized, or at least enough that you're making sure that it's very clear in your estimation that the client is no longer represented. Here you see us being able to communicate by SMS directly from the application. That information is then logged immediately back into the record. You can do this with either a document such as a retainer to execute representation, or the decline letter. You can do it in the same way. Here you see that the staff is notified whatever the disposition is of the particular document that's gone out, and the application does all these things automatically for you.
Yeah, and I think the important thing is, I think especially with you all, I assume on this call, because the kind of lawyers that usually attend these kind of webinars are certainly very progressive and looking for ways to automate your practice and to make things easier. And I think that's really important. And then what we encourage is, amongst all the efficiencies, is how can you use technology to document, to document, to document, just so that you have an audit trail to if something ever were to arise. Because like we said at the beginning, this standard of reasonableness, the duty of competence when it comes to technology and the standard of reasonableness is only going to evolve. I think it's going to become harder for attorneys, and nobody wants to be the example that the state bar is going to use to make a point. So, and
I will tell you that when I was running a law firm, having a robust data solution was nearly a safe harbor. Being able to produce not only internal notes, but also phone records and logs, of being able to show the level of contact that you had with a particular client is just indispensable. It's no longer a he said, she said. It's you're providing tangible evidence of the communication, which just really creates a real safe environment for the firm.
So Rachel, I am super impressed. Eric and I have never come in under the time allotted the time that we've been allotted, but we're happy to answer any questions that the group might have.
Hey, that sounds great. Thank you so much for your efficient timing. That's always helpful. Always helpful. So far, we don't have any questions in the chat box, but if anyone wants to type any now, it's definitely the time. We'll give you some time here. Okay, so from Lisa Smith, does anyone have a due diligence checklist for vendors that they might share? And I'll put that, well, obviously to the group. And then, and Ginny and Eric, if you either have suggestions for a checklist itself, tips, traps for the unwary, that kind of thing, please feel free to start sharing your thoughts there.
Sure, I'll jump in just quickly. And first of all, I would definitely encourage collaboration. Share notes not only on due diligence checklists, but also on your feedback that you might have with the vendor. Referrals, as we know in our business, are an excellent source of information. But beyond that, I think the first thing you want to do as a law firm is know who you are. Know the practices, the needs of the practices. Make sure, for example, if you have an intake requirement, that the platform you're looking at handles intake. If you have a billing requirement, make sure that you have a platform that has the ability to integrate with a billing mechanism, or perhaps use your existing billing mechanism already. So take a real inventory of what your actual needs are, and then separately take an inventory of the things that you want to see. What is going to be the motivator for you making a transition? All of those things come into play. Then, of course, you want to make sure that the security is there. GrowPath, we have 2 issued patents directly related to cybersecurity. We have cybersecurity companies apart from the legal technology sector that are interested in licensing that. So those sorts of things are really important to consider.
That is definitely helpful. I'm going to share via the chat a couple links to blog posts on our site that might be helpful. And in the meantime here, well, let's first do the follow-up, which is how does one assess the responses from vendors that the vendor will protect attorney-client confidentiality? Hopefully, our blog posts will help a bit on that. And in the meantime, while I put these links up, if Ginny or Eric, you would like to elaborate, feel free.
Absolutely. So in North Carolina, they actually have, the attorney has a requirement, for example, to actually elicit that notification from the vendor that they will affirmatively acknowledge that there is an attorney-client privilege, and they're taking all of not only the reasonable steps, but the state-of-the-art steps to protect that information. So your vendor should absolutely be willing to provide that. We certainly would. We have, for instance, a vendor ought to be able to tell you their philosophy from how they developed their code to where they store their information. For example, all of the code in GrowPath is all U.S. developed. There's nothing done overseas. It's everything is done literally right down the hall for me. But beyond that, all of the cloud servers that are used are U.S. domicile. So the U.S. law is going to govern the access to that information. So those are the kinds of nitty-gritty detail that you really want your vendors to be straightforward with.
All right. That sounds very good. I've got 2 links in the chat box. Now, we've also had another question, which is, do you have integration with any larger case management software on your product?
So I alluded to this just a moment ago, but one of the real competitive advantages that we have at GrowPath is we own every line of code. There's not one piece of code that's not our own. So when we say we can integrate with anything, literally we can. What we have found is it's typically the other side that is the challenge. It's not really ours. We have both a REST API as well as the ability to customize API, which is essentially a programming interface. And so the answer is yes, we can and will integrate with just about anybody.
And also integrations with web form providers, chat providers, those online tools that a lot of attorneys are using to gather leads.
Excellent. Okay, so at the current moment, we don't have any other questions queued. So I'll give anyone else who might be forming any just a couple minutes to wrap up here. And then otherwise, I just want to thank you both for that presentation. We should have it archived and available. The recording should be on our website within the next few days, hopefully no later than Monday. Anyone who has registered should also receive the link to that recording automatically by email. We'll link to these 2 blog posts I've put in the chat box too on that space as well.
And Rachel, I just wanted to say as well as when the viewers, when they step away, or maybe when they speak with their colleagues, or they think about this in the future, by all means, please reach out to growpath.com. I love talking about this stuff. I'm passionate about the management of law firms and efficiency. Happy to talk about things even outside of intakes. This is my passion. It's my hobby. It's what I do. So I'm happy to be a resource to any of your viewers.
And Rachel, if you want to share my email, it's just GINNY@growpath.com. If anybody has follow-up questions, if they want to send them to me, I can certainly make sure that I can answer them or make sure they get connected with the right person.
All right, perfect. Thank you both so much for your willingness to help and provide more help to our viewers. It looks like no one has any other questions that they've expressed at this time, so we'll just leave them with that contact point if they have any at any point. And thank you both so much.
Thank you,
Thank you, Rachel.
All right, I hope you all have a wonderful afternoon.
You too.
You too. Bye.
Yeah.